When was the last time you actually read a terms of service agreement before clicking accept? If you are like virtually every other computer user on the planet, the answer is never. You have clicked through hundreds of them, thousands perhaps. Each time you install software, create an account, or update a service, a lengthy legal document appears on your screen. You scroll to the bottom without reading a single paragraph, check the box confirming you have read and agreed to the terms, and proceed. This behavior is so universal that it has become a running joke in technology culture. But what if those documents you are ignoring actually matter? What if buried in the dense legal language are clauses that fundamentally alter your relationship with your computer, your data, and the software you depend on daily? Microsoft, like every major technology company, updates their terms of service, privacy statements, and user agreements regularly. Most updates are minor, technical, or legally required. But some introduce substantive changes that affect what Microsoft can do with your data, what features you can access, and what rights you retain over the files and accounts you thought were yours. And because almost no one reads these documents, most users have no idea what they have actually agreed to. They do not know under what circumstances Microsoft can access their data, modify their services, or suspend their accounts. They do not know what information is collected, how it is used, or who it might be shared with. They are operating under assumptions about ownership and privacy that may not align with the actual legal agreements governing their digital lives. And that gap between assumption and reality is where power resides. Terms of service, often abbreviated as TOS, are legally binding contracts between a service provider and a user. When you create a Microsoft account, install Windows, or use OneDrive, you are entering into a contractual relationship. The terms document specifies what the company promises to provide, what you're allowed to do with the service, what you're prohibited from doing, and what rights each party retains. These are not mere suggestions or guidelines. They are enforceable contracts that courts recognize as binding. If you violate the terms, Microsoft can terminate your account, revoke your access to services, and potentially pursue legal action. If Microsoft violates the terms, you theoretically have legal recourse, though the agreements typically include arbitration clauses that prevent class action lawsuits and require disputes to be resolved through private arbitration rather than public courts. The reason terms of service matter is that they define the power relationship between user and platform. They specify whether you own the data you store on Microsoft services or merely license access to it. They determine whether Microsoft can change features, pricing, or availability without your consent. They establish under what circumstances Microsoft can access your files, scan your content, or share your information with third parties. They dictate whether you can transfer your account, what happens to your data if you die, and whether your agreement can be modified unilaterally by Microsoft with minimal notice. The fundamental asymmetry of these agreements is that they are drafted by corporate legal teams optimizing for the company's interests and liability protection. You, the user, have no ability to negotiate terms. You cannot strike clauses you find objectionable or propose alternative language. Your only choices are to accept the agreement as written or decline to use the service. This is called a contract of adhesion, a take-it-or-leave-it agreement where one party has vastly superior bargaining power. While courts sometimes limit the enforceability of particularly egregious adhesion contract terms, the vast majority of provisions in major tech company agreements are upheld as valid. Most users ignore terms of service for rational reasons. The documents are deliberately written in dense legal language that is difficult for non-lawyers to parse. They are extraordinarily long, often tens of thousands of words. Reading them thoroughly would require hours for each service you use. And even if you read them, you lack the legal expertise to fully understand the implications. Furthermore, the all-or-nothing nature of the choice means that even if you discovered objectionable terms, your only recourse would be not using the service, which for products as ubiquitous as Windows or Microsoft 365 is often not a practical option. The rational user behavior is to ignore the agreement, operate on reasonable assumptions about how the service works, and hope that the company behaves ethically even when the contract might permit otherwise. But this creates a knowledge gap that companies can exploit. Terms can include provisions that most users would find objectionable if they understood them, but because they go unread, they generate no backlash. Arbitration clauses eliminate class action liability. Broad data usage clauses permit activities users assume are prohibited. Unilateral modification clauses allow companies to change the deal after you have committed. And because challenging these provisions requires legal expertise and resources most individuals lack, they remain effectively unchallenged. Microsoft's terms of service have evolved dramatically over the decades, reflecting the company's transformation from a software vendor selling standalone products to a platform operator providing integrated cloud services. In the era of Windows 95 and Office 97, Microsoft's relationship with users was simple. You purchased a software license, received physical installation media, and installed the software on your computer. The license agreement granted you the right to use the software on a specified number of machines. The software operated entirely locally. Microsoft had no ongoing relationship with you after the sale. The terms were relatively straightforward because the relationship was limited. The introduction of Windows Activation and Windows XP began changing this dynamic. For the first time, your software had to communicate with Microsoft's servers to verify it was legitimately purchased. This required Microsoft to track which license keys were activated on which machines, creating a database of users and their systems. The terms of service expanded to cover this activation system, specifying that Microsoft could verify your license and revoke it if it appeared to be pirated. Windows 10 marked the major inflection point. Microsoft shifted to Windows as a service, a model where the operating system would receive continuous updates rather than being a static product. This required persistent telemetry, diagnostic data sent from your computer to Microsoft to identify bugs, compatibility issues, and usage patterns. The privacy statement expanded dramatically to cover this telemetry, specifying what data was collected, though often in broad categories rather than specific details. Simultaneously, Microsoft began aggressively pushing Microsoft accounts, cloud identities that linked your Windows installation to an online profile. Once you signed in with a Microsoft account, your settings, preferences, and activity could sync across devices and be stored on Microsoft's servers. The terms governing Microsoft accounts are substantively different from traditional software licenses. They include provisions about account suspension or termination if Microsoft determines you have violated their acceptable use policies. They grant Microsoft the right to access your account to enforce these policies, comply with legal obligations, or protect their services. They specify data retention periods and circumstances under which Microsoft may delete data. They establish that your account is personal and non-transferable, meaning you cannot sell it or bequeath it in a will without Microsoft's permission. OneDrive and Microsoft 365 further complicated the relationship. When you store files on OneDrive, those files physically reside on Microsoft's servers. The terms specify that while you retain ownership of your content, you grant Microsoft a license to use, modify, and distribute that content as necessary to provide the service. This license is required for legitimate technical reasons, like replicating your files across data centers for redundancy, but the broad language could theoretically permit other uses. Microsoft 365 subscriptions introduced recurring payments and the concept that your access to software depends on maintaining an active subscription. The terms specify that if you stop paying, your access to applications ends, though you retain access to files stored on OneDrive. Copilot and AI services represent the latest evolution. The terms governing AI features specify that your interactions with Copilot, your prompts, and the AI's responses may be used to improve the service. They clarify that AI-generated content may not be unique, meaning another user could receive similar outputs. They include disclaimers about AI accuracy and limitations on liability if AI-generated content proves incorrect or harmful. These provisions reflect the unique challenges of AI services, where the output is generated dynamically and cannot be guaranteed. The concerns users express about Microsoft's terms cluster around several recurring themes. Privacy stands foremost. Users want to know what data is collected, how it is used, and who can access it. Microsoft's privacy statements disclose data collection in broad categories but lack granular detail. They state that diagnostic data is collected, but do not list every specific telemetry point. They describe data usage for service improvement, but do not specify exactly what improvement activities occur. This vagueness creates uncertainty. Users cannot verify that only the disclosed data is collected. They must trust Microsoft's representations. The privacy statement includes provisions allowing Microsoft to access user content in specific circumstances, to comply with legal obligations like court orders, to enforce the terms of service by detecting prohibited content, to protect the security of the services. These are reasonable provisions, but they mean your files on OneDrive are not absolutely private. Microsoft has technical and legal ability to access them. While they claim not to routinely access user content, the agreement permits it under defined conditions. Data retention is another concern. How long does Microsoft keep your data after you delete it or close your account? The terms specify retention periods for different data types, but acknowledge that deleted data may persist in backups for some time. Users who want their data truly gone have limited ability to verify deletion occurred completely. Account dependency creates anxiety about lock-in and arbitrary enforcement. If your Microsoft account is suspended, you lose access to Windows login on devices configured with that account, OneDrive files, Microsoft 365 subscriptions, and any digital purchases tied to the account. The terms grant Microsoft broad discretion to suspend accounts for violations of acceptable use policies. While egregious violations like distributing malware are clear, Some policy provisions are subjective. Users worry about false positives, automated systems incorrectly flagging legitimate behavior, or disputes about whether content violates policies. Service modifications concern users who depend on specific features or pricing. The terms include provisions allowing Microsoft to modify or discontinue services with limited notice. If you rely on a particular feature for your workflow and Microsoft removes it, the terms specify that this does not entitle you to compensation or refund. Pricing can change with subscription renewals. While Microsoft typically provides advance notice, the terms do not obligate them to maintain pricing indefinitely. Cloud integration raises questions about service availability and offline access. If Microsoft's servers are down, OneDrive synced files may be inaccessible unless you configured local availability. If your internet connection fails, cloud-dependent features become unavailable. The terms typically include disclaimers that services are provided as is without guarantees of uptime or availability. This shifts risk to users who depend on cloud services for critical work. Many user concerns stem from misconceptions rather than actual terms. Some users believe Microsoft reads all their emails or scans all their documents for advertising purposes, which Microsoft explicitly denies and which would violate their stated policies. Others believe they own nothing and Microsoft can arbitrarily confiscate everything, which misrepresents the actual legal relationship. Separating founded concerns from unfounded fears requires actually reading and understanding the agreements. From Microsoft's institutional perspective, terms of service are not mechanisms for exploitation, but necessary legal frameworks for operating complex global technology services responsibly. The length and complexity of these documents reflects the complexity of the services they govern. Microsoft operates in nearly every country, each with different legal requirements. They provide services to billions of users with wildly varying needs and expectations. They must protect themselves from liability while enabling functionality. This requires comprehensive, carefully drafted legal agreements. Terms are updated for several legitimate reasons. Legal and regulatory changes require corresponding agreement modifications. The European Union's General Data Protection Regulation necessitated substantial privacy policy updates to ensure compliance. California's Consumer Privacy Act imposed additional requirements. Each jurisdiction's laws must be accommodated. New product features require new terms. When Microsoft launches a new AI service, the agreement must specify how that service operates, what data it uses, and what limitations apply. Without these provisions, the service cannot launch legally. Security and abuse prevention justify many provisions users find intrusive. The ability to access accounts to investigate security incidents or policy violations is necessary to prevent malware distribution, fraud, and illegal content hosting. While this power could theoretically be abused, Microsoft argues their incentives align against abuse. Violating user trust would damage their reputation in business. They gain nothing from accessing user data beyond what is necessary for legitimate operations. Liability protection is crucial for any company offering services at global scale. Disclaimer clauses limiting Microsoft's liability for service outages, data loss, or AI errors protect the company from potentially bankrupting legal exposure. Without these protections, the risk of offering services would be prohibitive. Arbitration clauses reduce litigation costs and provide faster dispute resolution than court proceedings. While critics argue they favor companies over individuals, arbitration can also benefit users by providing accessible dispute mechanisms without requiring lawyers. Data usage provisions enable beneficial features users value. Setting sync requires storing settings in the cloud. Personalized recommendations require analyzing usage patterns. AI services require processing user inputs. The terms specify these uses because they are necessary for the services to function. Microsoft argues that users who find these uses objectionable can disable the features, though this may degrade functionality. The unilateral modification clause, which allows Microsoft to change terms with notice but not requiring renewed consent, is standard across the technology industry. The practical alternative would be requiring affirmative consent for every change, which would create enormous friction and prevent timely updates for legal compliance or security improvements. The provision includes a mechanism where continued use after notice constitutes acceptance, and users who disagree can discontinue use. While imperfect, this balances operational necessity with user agency. Microsoft emphasizes that their business model, unlike advertising-focused platforms, aligns with user interests. They profit from selling software and services, not from monetizing user data for advertising. While they collect data, they argue it is primarily for product improvement and service operation, not for building advertising profiles. This distinction, they claim, means their incentives favor protecting user data rather than exploiting it. The debate over Microsoft's terms of service is ultimately a proxy for a much larger question about the nature of digital age agreements and the relationship between individuals and the platforms that increasingly mediate modern life. We have created a system where participation in society, accessing employment, education, commerce, communication, requires accepting legal agreements that almost no one reads or understands. These agreements govern access to essential tools and services, yet they are drafted unilaterally by corporate entities optimizing for their own interests within legal constraints. This creates a profound democratic deficit. In theory, contracts require mutual consent and a negotiated agreement. In practice, adhesion contracts for essential services are closer to private legislation. The platform sets the rules. Users comply or are excluded. There is no meaningful negotiation, no ability to propose alternatives, no democratic process for determining what terms are fair or reasonable. The balance of power is fundamentally asymmetric. The length and complexity of agreements exacerbates this. Even users who want to read terms encounter documents written in legal jargon, stretching tens of thousands of words, referencing other documents incorporated by reference and updated frequently. Comprehensively understanding the agreements governing your digital life would require hundreds of hours and significant legal expertise. This is not realistic for ordinary people managing their daily lives. Yet, the legal fiction persists that clicking "I agree" represents informed consent. The cumulative effect of these agreements is that users operate under a set of rules they do not understand, cannot negotiate, and can barely even access in meaningful form. They form mental models of how services work based on reasonable assumptions, common practices, and marketing claims. But the actual contractual reality may differ substantially from these mental models. And when conflict arises, the written agreement prevails over reasonable expectations. This raises fundamental questions about digital ownership and sovereignty. Do you own the files stored on OneDrive? Or do you merely have a license to access them subject to Microsoft's terms? If Microsoft can suspend your account for policy violations, and the policies are defined unilaterally by Microsoft, do you truly control your digital life? If the terms can be modified with minimal notice and continued use constitutes acceptance, is this really a voluntary agreement or a system of imposed rules? The broader trend is toward platform-mediated existence where more of life occurs through services governed by corporate terms rather than democratic laws. Your social connections are on platforms with user agreements. Your work documents are in cloud services with terms of service. Your creative output may be generated by AI systems with usage policies. Each layer of mediation introduces another set of rules you did not help write, cannot change, and may not understand. Some argue this is the inevitable cost of the complexity and scale of modern digital services. Creating legal frameworks that billions of users could meaningfully participate in negotiating is practically impossible. Others argue this represents an unacceptable concentration of private power, and that stronger regulation is needed to impose minimum standards, prohibit abusive provisions, and ensure genuine informed consent. The tension between these positions defines much of the current technology policy debate. Ending 1830-20 code. The terms of service you scroll past without reading are not mere legal formalities. They are the constitutional documents of the digital age, defining the rules under which you interact with the platforms that structure modern life. And those rules are not neutral or inevitable. They are chosen, drafted by corporate legal teams, optimized for company interests within the constraints of law, updated frequently to accommodate new business models and minimize liability, and accepted by billions of users who have neither read them, understood them, nor had any input into their creation. This system persists because the alternatives seem impractical. Requiring meaningful consent would make services unusable. Allowing individual negotiation would create chaos. Simplifying agreements would leave gaps and ambiguities that create legal risk. So we continue with a fiction. The fiction that clicking a button after not reading 40 pages of legal text constitutes informed consent. The fiction that users understand what they are agreeing to. The fiction that this represents a voluntary, negotiated contract between equal parties. But fictions shape reality. The terms you agreed to without reading determine what Microsoft can do with your data, what rights you retain, and what recourse you have when things go wrong. They determine whether your files are truly private, whether your account can be arbitrarily suspended, and whether you can seek remedies through courts or must submit to arbitration. These are not abstract concerns. They have concrete implications for your privacy, your security, and your autonomy. And the fact that most people are unaware of these implications does not make them less real. It makes them more dangerous because unexamined power is power most easily abused. The question we must confront is whether this system is acceptable, whether we are comfortable with a world where the rules governing our digital lives are written by corporations, imposed through adhesion contracts, hidden in documents no one reads, and modifiable with minimal notice, whether informed consent has become a legal fiction masking a reality of unavoidable compliance, whether the convenience of modern digital services justifies surrendering meaningful control over the terms under which we access them. There are no easy answers. But there is a first step. Read the agreement. Not every agreement for every service. That is not realistic. But the important ones, the platforms you depend on, the services that hold your data, the tools that mediate your work and relationships. Understand what you are actually agreeing to, because the most important changes in technology are often hidden in documents few people read. The rules that govern the digital world are defined not by the users who inhabit it, but by the authors of terms no one agreed to because no one understood what they were accepting.